fighting soldiers from the sky, fearless men who jump and die, men who do just what they say, the brave men of the Green Beret, silver wings.
Thanks for joining the United Constitutional Patriots radio show. Our two hosts are Patriot Girl and Greg. Now I will turn the mic over to Patriot Cowgirl. Go ahead, Patriot Cowgirl.
Hi, welcome to United Constitutional Patriots Radio, where the news is 100% true, always vetted. Tonight, our first guest is Agus McIntosh, and he's going to be speaking to us about the federal land ownership and the limitations on the federal government. Go ahead, Angus.
This is Angus, and I was asked to talk about federal land ownership and jurisdiction. Do I have to have the button pushed down here? Can you hear me?
Yes, you have to push the button down.
Oh, okay. I thought I'd try to keep it simple. There's a lot of people that are true patriots, and they're under this impression. I've heard some of them say, the government can't own land at all. Constitution forbids it. And I used to be in the camp. I used to think that many years ago, but I've been doing this research for about 30 years, and that is not what the Constitution says. And a lot of people get some things mixed up. They get Article 1, Section 8, Clause 17, mixed up with Article 4, Section 3, Clause 2. Now, Article 1, and this is fundamental to understanding jurisdiction and ownership, because those are two different things. The government can actually own land within the boundaries of a state and have absolutely no jurisdictional authority over it all. And there's statutes on this, there's Supreme Court decisions. The problem is when people read Article 1, Section 8, Clause 17, they want to insert the word ownership or own or property, where Article 1, Section 8, Clause 17 is not talking about that. What it's talking about is exclusive authority or exclusive legislative authority. And in Article 1, Section 8, Clause 17, if you've got your pocket Constitution, you can get out and look at it. But from my memory, it says that the federal government shall have jurisdiction over 10 miles square, which shall be for the seat of government, and shall exercise like authority. It says that the federal government shall exercise exclusive legislation over an area 10 miles square, and shall exercise like authority over all areas purchased with the consent of the state legislature for forts, magazines, arsenals, dockyards, and other needful buildings. So that section is primarily, and some people say, well, the Supreme Court got it wrong. Well, let me start out by just saying you can't do that, and I'll tell you why. You can't say, well, I'm going to believe the Supreme Court on this decision, but I'm not going to believe them on this decision. And usually what I found when people bring up an objection to a Supreme Court decision is typically what they have done is they have mixed up the terminology. For example, a lot of cases dealing with public lands. All right, that term public land has a specific defined meaning in the law, and every term in the English language that's used in the law has a definite meaning. If it didn't, then we could not have any criminal statutes that could stand up to a test in court, because words have to have defined meaning. And the term public lands has a defined meaning. It's not anywhere in the Constitution, but the Supreme Court has addressed it and Congress has addressed it. And originally it was just the land of the United States. And I'm going to give a couple of references for anybody who wants to take notes. There's a website called Justia, Justia, and you can look up any Supreme Court decision very quickly on that website. And there's a decision called U.S. versus Grayshot, Gratiot, from, I believe it's 1840. There's two cases. One is 1840, one is 1841. And one of the cases has to deal with just some contractual issues with this gentleman, Grayshot. And the other one has to deal with what the federal government can own, okay, as far as land goes. And in that decision, the Supreme Court said that Article 4, Section 3, Clause 2, that talks about how Congress has exclusive authority to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States, that territory that's spoken of is what constitutes the lands or the property belonging to the United States. Now, a lot of people say, well, at the very beginning, the 13 original colonies owned all the land, all federal land. Well, that's true. Under the Articles of Confederation, there was no federal land. And that is why some of the states refused to sign the Articles of Confederation until some large states like Virginia and New York that had huge Western claims put up. Now, I'm going to give you another case that will help people understand the difference between legislative authority or jurisdiction, which is covered by Article 1, Section 8, Clause 17 of property by the federal government, which is covered by Article 4, Section 3, Clause 2. And the Supreme Court talks about it. It's a case called United States versus Texas. It's a 1950 case. So if you go to the Justia website and you just type in U.S. versus Texas, 1950, it will bring that case up. You can read the case, and it will explain that the equal footing doctrine has nothing to do with ownership of land, everything to do with legislative authority. That means what the state can exercise jurisdiction over. And the Supreme Court explains in both of those cases, and in other cases that are referenced within those two cases, they explain that there's a difference between owning land and having jurisdiction over the land. Now, I'm going to give a third case that people can go and look up and can read. It's called Wilson versus Cook, 1946. Okay, so getting back first, we'll talk about ownership, then we'll talk about jurisdiction. But some people like to point out that Article 1, Section 8, Clause 17 says that Congress can purchase land for forts, magazines, arsenals, dockyards, and other needful buildings, essentially military uses. Okay, and now if you want to be literal, it doesn't say anything about post offices. It doesn't say anything about federal courthouses or federal prisons. or a building to house the Customs and Border Enforcement or customs houses. But the Supreme Court has said when it says other needful buildings, that means other property that the United States needs to purchase in order to carry out the functions of government that are specifically provided for in the Constitution. So the government can own land. They can own land for military bases. They can own land for post offices. They can own land for courthouses. They can own post roads. Okay, now that's ownership. Also, the Supreme Court said in that first case I mentioned, U.S. versus Grayshot, the issue there was the state of Illinois was complaining that the United States had retained ownership of minerals within their state after the state became a state, and the federal government had retained ownership. And they argued very strenuously that, you know, they felt that the United States could not own that land and then lease it out for mineral development. And the U.S. Supreme Court disagreed, and it was a unanimous decision. It's been adhered to ever since, and although people may disagree with it, I'm just saying that is the view of the Supreme Court. The federal government can own land within a state after it becomes a state. Some people might not like that. They may disagree with it. I'm okay with that. I'm just telling you, if you ever go to court and you try to argue against it, it's been argued numerous times and lost. Most recently in 1987 by the state of Utah. But the thing that will, I think, help people to deal with this is understanding there is a difference between owning land and having jurisdiction. And on this land that the state, in Article 1, Section 8, Clause 17, it has to, in order for the federal government to have legislative authority or jurisdiction over any land that the government owns, a general grant of jurisdiction, it has to get the permission of the state. That the state has to cede jurisdiction to the federal government. There's quite a number of court cases on this where Fort Leavenworth, Kansas is a good example. The government owned the land before Kansas became a state. They made a fort out of it. Kansas later became a state. A murder was committed in Fort Leavenworth, Kansas. It was prosecuted by the federal government, went all the way to the Supreme Court, and the Supreme Court threw it out because they said the federal government had no jurisdiction. Even though they owned the land, the state had jurisdiction to punish crimes, and therefore they threw that out. Well, later, the federal government went to the Kansas legislature, asked for the state to cede jurisdiction over Fort Leavenworth to the federal government, which the state did. Then later, there was another murder committed in Fort Leavenworth, and this time it was prosecuted by the federal government, and it stood because the state had ceded that jurisdiction. Now, this type of ownership where the federal government owns land, but it does not have jurisdiction, is called proprietary ownership. It's proprietary land. They're just simply a landowner like any other landowner. So this 1946 case I told you about, Wilson versus Cook, illustrates that very clearly. That was a case where someone had purchased timber from the federal government, and the state charged tax on that timber, even though it was still standing in the national forest. It was a timber sale, and it had not yet been harvested. The state said, well, we can tax that because we have jurisdictional authority. Of course, the guy that bought the timber tried to argue, no, this is federal land. There's no state jurisdiction. The Supreme Court unanimously disagreed. They said there is no federal jurisdiction unless the state has specifically ceded it. And they said that this is true for all national forests, whether they were established before the state gained statehood, or even if it was purchased land, the federal government had purchased later and added to the national forest, the federal government still had no jurisdiction. And as a matter of fact, if you look in the Forest Organic Act of 1897, it says in very plain, specific language, the federal government does not have any jurisdiction and the citizens do not lose their rights under state law. It says the same thing in what's called the Weeks Act of 1911, which was the authority the federal government purchased all the Eastern National Forest under. It says the same thing in the Taylor Grazing Act, 1934. And as a matter of fact, in the 1930s, the government was buying up failed farms that ranchers and farmers, they couldn't make a living in during the Dust Bowl and the Great Depression. People were just walking away. Federal government started a program of buying up this land, and so the people would get something for it. Later, that was put into what was called national grasslands. And I'm sure some of you have heard of that. But national grasslands, there was this myth, this assumption that the federal government somehow had gained jurisdiction over that. So in 1946, Congress also passed a specific law saying that any land the federal government had purchased over the previous 10 years under about 6 different laws that they had passed, any land that they had purchased to put into these land resettlement projects, they did not have jurisdiction over. And if anybody thought that they had jurisdiction, it says Congress hereby cedes back jurisdiction to the state. So now that we got jurisdiction established, people are going to say, well, what about this case, Kleppe versus New Mexico, or any of these other cases where people, even the states, had argued we have jurisdiction, but yet the federal government won the case. This is where you have to be aware of the specific language that's being used. What the Forest Service and the BLM have programmed people into using is the term public lands. Now, as I said before, every term in the English language used in the law has a definite meaning. And the term public lands is defined by both Congress and the U.S. Supreme Court as land or interest in land, such as standing timber or minerals, land or interest in land that belongs to the United States, upon which there are no rights or claims that belongs to the federal government. In other words, you would have to go back 150 years or more in Oregon, for example, to find any public land that nobody had, because the very moment someone settles on a piece of land, marks out the borders and claims it, the Supreme Court has said in numerous cases that takes that land out of the class of public land available for disposal. And that's the second requirement for public lands. It has to be owned completely by the United States, have no claims or rights of any kind attached to it, and it must be available for disposal. Well, automatically that takes almost everything out of that class of public lands. But under the law, if it is classified, if you go into court, for example, the 1976 Kleppe versus New Mexico case, the state of New Mexico went into court arguing that it had jurisdiction over public lands. Well, that is not so. Okay. If you claim that it's public land, by legal definition, it belongs to the United States exclusively, and there are no rights or claims. Okay, if there are no rights or claims and it belongs to the United States, then they have all legislative authority over that. But the point is, a national forest is not public land. The Supreme Court already said so. And the reason is because there are split estate rights. There are RS 2477 right-of-ways. There are water rights. There are grazing allotments. All of these are actual rights, property rights granted by acts of Congress over time. And that is what removes, as a matter of fact, there is a statute, the Federal Power Act of 1920 specifically defines the term public lands. And it says public lands are not reservations, such as national forests, national parks, national monuments, and it goes Indian reservations, and it goes down the line. And because they are not, quote, public lands, then that means there isn't even a pretense of federal jurisdiction. So the federal government can own land, and it can also, Congress has this exclusive authority, and Congress can do it any way they want, and they have over time. They have granted water rights, they've granted right-of-ways for railroads, right-of-ways for ditches and canals, for public roads under RS 2477, grazing allotments. There are all kinds of split estate property rights that Congress has granted. And this caused a lot of confusion in the land office, the land department, in the late 1800s. And Teddy Roosevelt, and there's a court case, Supreme Court case from 1982 called Butt versus Western Nuclear, where this is all discussed in detail. But in the early 1900s, Teddy Roosevelt, in his State of the Union address, 1909, said, listen, the only way we're going to straighten out this mess in the West is to completely adopt the split estate policy, give a surface title of a type to the ranchers, dispose of the surface as allotments, grazing allotments, and retain the timber, the commercial timber, and there's a difference between just firewood and such and like as that, and commercial timber, but retain the commercial timber and the mineral estate for separate disposal. And some people have heard my talk and I say, oh, you're saying the government can keep the minerals and the timber. No, they kept it for separate disposal. They were going to, so that you could still go out there, have a timber sale, you could still go out there, take up a land claim, you can still go out there, get an oil or gas lease. And if you think about this logically, the only kind of disposal or entry that you've been able to make in a national forest since 1924 is either a timber sale or oil or gas lease or a mining claim. Because in 1924, Congress confirmed all the titles of ranchers who had grazing allotments or ranges on national forest, and they also at the same time did the same thing for ranchers who were not in national forest, but were ranching on land that was, quote, valuable for grazing and raising forage crops. That is how, Congress has this power. They don't have to issue a patent. The idea that you don't own something unless you have a patent. Well, Congress can dispose of land any way they want. This is an exclusive power under the Constitution, if you read it, that they have. They can dispose of land any way they want. So with RS 2477 right-of-ways, it just simply says on Section 8 of the Act of 1866, it says the right of way for the construction of highways over the public lands, not reserved for other purposes, is hereby granted. That was an immediate grant, a grant in presenti. There was no need to apply. There was no requirement that you had to use it for a certain period of time. There was no requirement you had to have it recorded. It just said, if you need it, it's yours. And therefore, every county road and every state highway that crosses so-called federal land in the West has, as the basis of that state or county or private right-of-way, RS 2477, the Act of July 26, 1866. So this idea that you have to have a patent is erroneous. There's two ways, or there's two title documents that the government issues. And this is a pattern and practice that they have followed since the earliest land disposal law in 1795. And that is, they will either issue a patent, or the other document is a official government survey map. So a grazing allotment map is an official government survey map. That map, made by the United States government, is a title document. It shows the boundaries. It has the name of the allotment owner on there. And therefore, it is a recordable title document. And there's a case, U.S. Supreme Court case from 1914 called Jones versus St. Louis Land and Cattle Company, in which the Supreme Court explains that when Congress passes an act intended to grant a right, and they do not require the issuance of a patent, that official government survey map is the title document. It also references about 5 other previous Supreme Court decisions on that same subject. So I've got a lot that I'm covering here, and I'm trying to cover in a short amount of time. I don't know how much time I have, but I'm gonna, you just interrupt me anytime and you're ready to move on to the next guest. But I just wanted to explain how there is a difference between jurisdiction and ownership. In that case, 1976 case of Cleppe versus New Mexico, it was a unanimous decision against the state of New Mexico, because the whole argument in that case was they were trying to claim that the state has authority over, quote, public lands. Now, if on the other hand, the rancher in that case, Kelly Stevenson, if he had brought up and said, well, wait a minute, this is a grazing allotment, that changes the whole argument. It changes the whole case. Because just like in Wilson versus Cook, the Supreme Court said that once the title, that timber, passed from the federal government to the private individual, the state had full jurisdiction. That's why understanding the split estate is so important to asserting jurisdiction. Because as long as you're going into court arguing that, well, this is public land, Your Honor, and we have some kind of right on public land, you're shooting yourself in the foot. Because by legal definition, there are no rights on public land. And these federal employees have been programmed, and you see it on all their signs, but they've been programmed to continually call it public land. Now, it sounds sexy. It sounds like, well, this must be open to the public. But the truth is that the legal definition precludes any rights at all. Whereas in a national forest, you do have rights. Even if you're a citizen, say you're not a rancher, you just are a resident of a county that has a national forest in it, under the original Forest Service Organic Act and the original Forest Creative Act, 1891, You have a right as a resident of that county to cut wood for construction, fencing, firewood, and domestic uses. So whatever, and the way the Supreme Court has defined that, the term domestic does not mean household, it means local as opposed to foreign and domestic. And that term domestic means for local uses, local businesses. So as long as you're using that within the state and you're a resident of that state, you have the right to the use of that timber. And there's court cases on that. But the main point I'm trying to make tonight is, as long as you keep calling it public land, what you're saying is there are no rights. Because as soon as a right attaches to public land, it ceases to be public land. As soon as RS 2477 right of way attaches to that land, it's no longer public land. Now, that RS 2477 right of way belongs to a county, or belongs to a state highway, or it belongs to an individual who just owns a isolated parcel somewhere out there. They have a right of way. If it's a grazing allotment, that rancher has a surface right for all agricultural and ranching purposes. That's how the Supreme Court put it. Now, one thing I want to be clear, because the Supreme Court has addressed this in 1928 in a case called Kinney Coastal versus Kiefer, the rancher doesn't have an unlimited ownership of the service. He owns it for all agricultural and ranching purposes. He can't go out there and start subdividing and building houses and putting up condominiums and putting up a town or something like that. But for all agricultural uses, he does have a right, and the Supreme Court has said that. The problem is, so few people understand that these rights exist, and when they go into court, they shoot themselves in the foot by trying to argue they have a right to graze on public land. Well, those two terms are exclusive of each other. You can't say I have a right on public land, because there are no rights on public land. And that's exactly why they want you to use that terminology. We've got to start using the right terminology. If your argument is over access to a road, you've got to make sure you're making an argument that this is a RS 2477 right of way. And you've got to make the argument that this is a grazing allotment, or that there is a water right that you have a right to have access to. And so that is, as soon as a right attaches, then the federal jurisdiction ends. Because who has jurisdiction over private property within the boundaries of a state? The state and its political subdivisions, the county. And that's where your county sheriff can exercise his authority. Does that make sense? Okay, I guess I'm still on the air.
Yeah, you're.
Anyway, I don't know if people want to ask questions or if this is just informational, but I'm not sure of the format of the program. But the main thing to remember is that as long as there are private rights attached, the state has jurisdiction. As long as you're calling it public land, what you're saying is there are no private rights attached, in which case the federal government has this authority to make rules and regulations as if it was any other property owner, not enclave jurisdiction, but the authority to make rules and regulations as any other landowner can. Now, you can make decisions about the use of your own property, even though the state has criminal jurisdiction over it. And that's the same situation with the federal government. It's not a full authority. It's only the same limited type of authority that any other property owner would have. But what is really killing us in these court cases in the West, whether it has to do with predators like grizzly bears or wolves or anything else, is we're arguing it's public land, but then there's supposed to be some kind of state jurisdiction there. Now, the state does have, according to the Supreme Court, has jurisdiction over all wildlife. As far as endangered species goes, the original Endangered Species Act was 1913. It was held to be unconstitutional in 1915. It was rewritten again in 1918 and upheld by the Supreme Court in 1920. And the reason it was upheld is because endangered species can only be migratory, non-resident species. So basically, Canadian geese, sandhills cranes, birds that cross borders, international borders. That is what the Supreme Court said in 1920. That didn't change. There was there were several amendments in 1929, 1935, 1946, I believe, 55, and 1966. And in 1966, the name of the Migratory Bird Treaty Act was changed to Endangered Species Act. And then again in 1973. So everybody, 73, I think. So everybody refers to the Endangered Species Act in 1973, but it really isn't the Endangered Species Act of 1973. 1973 was just an amendment to a much bigger law. All of those previous laws were actually referenced, incorporated by reference in the 1973 Act, and it's what's called paramateria. All acts on the same subject have to be read together as one law. So if you go back to 1929, Congress said that the United States cannot establish any wildlife zone or wildlife management area within a state without the permission of the state. And also, even if it was in a national forest, they would have to get permission of the allotment owner. So what is killing us is a lack of understanding or knowledge of the laws and what the meaning of the term public lands is, and the fact that there is a difference between ownership and jurisdiction. Now, the only thing,
Dr. Angus, could I hold your thought there, sir? We have a special news bulletin Chuck needs to get out real quick, okay?
Okay.
Go ahead, Chuck.
Yes, sir. We will return. We interrupt this broadcast for a major news bulletin. I always wanted to do that. We'll return to our guest momentarily. This is only going to take me a couple of minutes. But something major has happened. Now, folks, we have all of us here and all of you I know, for the last couple of days, we've been listening to this three-ring circus of a hearing for Judge Kavanaugh, and everybody's been, as mad as can possibly be at the Democrats, and on and on and on and on. Well, it just came out just a little bit ago, about 20 minutes or so ago. It was on Fox News, ladies and gentlemen. This was Fox News. The Senate Majority Leader, Mitch McConnell, has announced, he said, I'm pleased to announce that all 51 Republican members of the Senate support the motion to proceed to the nomination. Repeat, I'm pleased to announce that all 51 Republican members of the Senate support the motion to proceed to the nomination. So apparently now all 51 Republican members of the Senate are on board, and they are prepared to proceed to the nomination. So we're getting closer to this vote all the time, ladies and gentlemen. This thing is about to happen. Johnny, I'll turn it back over to our guests and to you.
Okay, Dr. Angus, I appreciate that, Chuck, and I turn back over to you. Sorry for intervening with you, sir.
That's great news. I think we're going to have a wonderful person there in Brett Kavanaugh, because what we need are strict constructionists. Because in reality, folks, the people that look out there and say, oh, there's a national forest, they're claiming they have jurisdiction. 90% of the problem in all of these cases that people like to cite, like Kleppe versus New Mexico, is the misunderstanding of what a national forest is. The original National Forest Act was passed in 1817. 1817. And that was right after the United States acquired Spain, or from Spain, acquired Florida. And the federal government felt that there was live oak and red oak timber in that panhandle of Florida and in other areas of Florida that was perfect for shipbuilding. Now, this goes back to the folks that are saying, well, the government can only own land for forts, magazines, arsenals, dockyards, and other needful buildings. Well, that's a military use. These were naval reserves, and the land and the timber was reserved for the use of the Navy. But the land itself could still be settled on. And so when they started creating forest reserves in the West in the late 1800s, if you read the U.S. versus New Mexico decision in 1978, the Supreme Court made it very clear. The only thing that was reserved was the timber. The land wasn't reserved. The land was open. As a matter of fact, it was open for disposal. As a matter of fact, in U.S. versus New Mexico, the Supreme Court said that the 1891 Act was essentially a homestead law. So the idea was to dispose of the land, but retain the timber for either government use or for separate disposal. And it's the same thing with the minerals. It's just that very few people understood the law. They think in terms of an entire ownership, where if you get a patent to a piece of land, you own everything from the center of the earth to the heavens above. And that was true in the East, because all the land in the East was classified under the federal classification system as agricultural land. But under agricultural land, you could only get 160 acres or 320, or the maximum was 640. If it was a husband and a wife, each homesteading 320 acres. On the other hand, mineral lands, because after 1853, the only thing a settler could get on mineral lands was a surface right of occupation and cultivation. And so it was in the West, where you need 10,000 acres to survive on, not 160. Congress passed this act in 1853, which allowed settlers to get a surface right to any amount of land necessary, the amount of land necessary for the support of a family. It was called a farm unit. Now, out of that land, they could, in addition, if they wanted to, pick out their favorite spot and acquire, under the agricultural land laws, 160 acres. And this is all in the Act 1866, Section 10 of the Act of July 26, 1866. It's just that most people don't know these laws. I happen to know them because I've been studying them for 30 years. But the Supreme Court decisions are clear. Everybody looks at a map of the West, and they say, oh, the federal government owns, all these hundreds of millions of acres. Well, the federal government does not own all those hundreds of millions of acres. Those are split estates. And if you look at closely at most of these maps, BLM maps, what it says is surface and subsurface ownership, because they understand that the federal government doesn't own the surface estate on all that land. A lot of places, all they own is the mineral rights. And because it's a split estate, people keep making the wrong arguments. They assume wrongly that the federal government owns all the land from the center of the earth to the heavens above. But that's not how they disposed of it. And nobody, here's a logic test. Would anyone have come west and settled on the land, built a ranch, if they knew that 50 or 100 years later, the federal government could just come along and take it away from them? No, they wouldn't. Nobody would risk their lives, their years, their fortune putting in improvements, stocking the range with cattle, spending their lives there, if they believed for 1 second the federal government could just come along and take it. Congress made a legislative grant in 1853 so that these ranchers could come out, take up the amount of land that they needed. Their only requirement was they had to mark the boundaries, they had to actually improve the land, and they had to satisfy the cultivation requirements. Now, the grazing or raising of livestock was considered, always had been considered by the land department as fulfilling the cultivation requirements. And it's even in their regulations back in the 1800s. And there's court cases on it. And so the problem isn't with the bureaucrats. The problem is our lack of understanding. Now, I know this for a fact because I've been back to Washington, D.C. I've sat down at a table with Neil Cornsey on one side, Michael Bean across the table from me, the Forest Service Assistant Secretary, just two people down from me. So I've talked to these people. I've been with them in person, and they know that this is a split estate out here. They know it, but they feed this crap to their employees. Don't expect to get any satisfaction from the local BLM or Forest Service employees because they are just as clueless as in the dark as everybody else. They don't know about these laws. All they do is parrot and repeat what is told to them. And the people at the Washington office tell them lies just like they tell everybody else lies. And the same people that have been at the BLM have been there for 20, 30 years. They've been there through Obama. They've been there through Bush the first and Bush the second, through Clinton. These people have been there for a long time. This is the deep state. And we've been seeing it with the FBI, the corruption with the Department of Justice, and they are just as corrupt in Department of Interior and U.S. Forest Service. Now, I don't know if the people that President Trump has selected as Secretary of Agriculture and Secretary of Interior, I don't know if they know any more about this than anyone else, but I sincerely doubt it. I think what they're doing is they're just taking direction from the people that are the career bureaucrats that have been there for 30 years, that have been propagating these lies, perpetuating the myth of public lands, instead of telling the truth that, hey, these are split estate lands out here. And I believe that if we can understand the difference ourselves and at least stop using the term public land, start calling it what it is, it's split estate land, or if you like a kinder euphemism, you can call it multiple use land, but it is not public land. Public land means there are no rights. It's wide open wilderness. Anybody who wants to can go out there and settle. And the fact is, there isn't anything like that left anymore. It's all split estate land. Congress has passed all these laws protecting the rights of the ranchers. So every time someone goes out to drill for oil or gas, they have to put up a bond. Now, why is that? Because the rancher owns that forage on the surface. And if oil and gas drilling destroys that or destroys his improvements, then they have to pay to fix that. But see, even most ranchers don't understand that. They don't understand what their rights are because we have taken it for granted that these federal agencies were telling the truth all these years when they've been lying. And you got to remember, Congress is who has the power to dispose of interests in, quote, public land when it was originally public land. They could have decided not to give that service right to settlers. But if they did, then nobody would have came west and settled. And the only way the federal government could hold on to Nevada or California right after the Mexican War was to put people out there who would be loyal to the United States. And the only way they could entice them to go is to say, well, you will have a surface right of occupation and cultivation. And this no one can take away from you. And this will give you a preference right that in the event that we ever dispose of the land in its entirety, then you will have the first right of refusal. That's what a preference right is. But they have decided to keep the minerals for separate disposal. I think there's a problem for the guys that feel like, well, we want the state to own all the minerals in the timber. I'm not saying that that can't happen, but Congress if you can convince Congress to sign over whatever it is they still own, which is predominantly the minerals and the timber, then, I say go for it. But the power under the Constitution given to Congress to decide how to dispose of the territory and other property belonging to the United States. And the Supreme Court has always held to that. When they start creating wilderness areas and they shut out mineral production and they shut down timber production, there's, I think, starting to be a constitutional problem there, because now they're saying, even though we only retained the minerals and the timber for separate disposal, now we're just shutting off access altogether. And I think that creates a huge constitutional issue there, because the policy of the Constitution is that of disposal, not of forever keeping it as a federal asset. So there might be some argument there. But my greatest apprehension is that well-meaning people will call it public lands and demand it all be turned over to the state, when in reality it's not public land, it's split estate land. And these ranchers and these farmers and these county roads and these other property rights that have already been granted will inadvertently be kind of glazed over or shoved under the rug, and a lot of hardship will occur to people in the West. But if we also are to realize that, hey, wait a minute, this is a grazing allotment, then you have to ask the question, well, who has jurisdiction over private property? And the Supreme Court's already answered that. The state and the local government does. So that's where we can begin to start making inroads to protect the freedoms of the people, is by realizing that, hey, the federal government doesn't own the surface estate. This is a grazing allotment. And that's why the federal government is systematically, and has been for many years, trying to drive ranchers off their allotment, because they think if we can get a rancher to throw up his hands, abandon his property, and walk away, then magically that private property is going to revert to the federal government. Now, there is no legal basis for that kind of assumption. That would be like saying if somebody abandons a homestead, that it's going to revert to the federal government. Of course not. It cheats to the state or to the county, and they will sell it for back taxes. So once property has been granted, then it's granted. They can't take it back. But this, I believe, is their strategy, is to try to get ranchers to abandon their allotments so that they can then try to claim that somehow it reverts back to the federal government. I think I've talked everybody's ear off. I want to thank you for letting me talk tonight. I hope if you have questions that you get them to me. I'll try to answer them as best I can.
I have a question for you, Doctor. Just can we talk about this in a couple examples that people can maybe understand a little better? Of course, you know, people want to know about the Bundy situation, and from what you just painted out, they had no authority to do with the Bundys. So let's start with that one. Let's talk about the Bundy situation. Here was a rancher. The federal government was trying to demand grazing fees that he felt were unconstitutional. Let's start with that one. What is your take on that?
Hey, real quick, Greg, when he gets done with your question, I'd like to ask him a question.
Okay, I was talking, but I forgot to push the button. So let me start again to answer that question. Bundy's had the right to be out there. They own their grazing allotment. They owned a right of occupation and cultivation from 1877 when they first settled on the land and marked out their boundaries and took possession of the land and were using it for grazing. That was a statutory grant. But Congress took it a step further. In 1823, they passed a special law which validated and cured all defects in title for ranchers in the West. And the grazing fee comes originally under the National Forest, since they existed before the grazing service and all the grazing districts outside National Forest. But in 1905, when the Forest Service was created, it was a transfer from Department of Interior to Department of Agriculture. So the Secretary of Agriculture wrote a letter to the Attorney General saying, hey, when we were under Department of Interior, we were authorized to charge administrative fees for making maps and performing surveys and doing these administrative record keeping services. We were authorized to charge fees. Well, now that we're under Department of Agriculture, can we charge fees? And the Attorney General just said, yeah, you can charge fees. No authority from Congress, but just his opinion. They started charging this administrative fee. Well, in 1914, when all the grazing rights in national forests were validated and adjudicated, then Congress passed a law which created a special fund called the Cooperative Improvement Fund. And so half of the money that ranchers paid in as these fees went into the Cooperative Improvement Fund and were supposed to be used to build fences and corrals and range improvements. And earlier, the Supreme Court, or in 1909, Congress passed a law called the 25% Fund Act. Since the federal government owned the minerals and timber in national forests and the ranchers only owned this surface grazing right, the states were complaining and saying, well, we can't really get property taxes off of there to make it worth our while to have these national forests in our state. And so Congress said, well, we'll give you 25% of everything we take in as fees. So the fees that the government collects are a service fee if you're using administrative services. 25% is supposed to go to the state and county in lieu of taxes, specifically, it says in the act, for roads and schools. And then 50% was supposed to build range improvements. And so 50, 25, and 25 adds up to 100%. And how much is a rent? Zero, because ranchers own their allotment. They own the forage. They own the improvements. They own, quote, the value of the land for grazing. This is all language straight out of the statutes. And so the fees the ranchers pay go for three specific purposes, three specific uses. And so people have the mistaken idea that it's some kind of rent. Well, it's never been a rent at any time. It's mainly to pay for services or a voluntary contribution to this range or cooperative improvement fund. And under the Taylor Grazing Act, it was changed to range. I think it was called Range Development Fund. And under the Federal Land Policy Management Act in 1976, they combined the Forest Service and BLM funds into what's called the Range Betterment Fund. And so that money that ranchers pay in is what pays for water developments and fence lines and pipelines and everything. And so when the environmentalists say, oh, these are welfare ranchers and the taxpayers paying for all these improvements, that's a lie. It's just simply a lie, a bald-faced lie. The ranchers have been paying all along for every range improvement that's out there. That money goes in the Range Betterment Fund. It's a special fund in the Treasury. It does not go into the Treasury general fund. It goes into a special fund, and that's what pays for the range improvements. And since Bundy already owned the forage and the value of the land for grazing within his grazing allotment, he was not in trespass. But the problem was, just like with every other rancher, Bundy knew he owned something. But if you were to sit down with Cliven and say, well, can you explain to me exactly what the laws are that give you these rights? Well, he wouldn't be able to tell you. And most ranchers wouldn't. So I'm not faulting him for that. But because he was unable to articulate that, and the government, on the other hand, went before a judge and they said, Your Honor, this guy is grazing on public land. Now that changed the whole nature of the case against him. If he had known to argue that, well, wait a minute, this is a grazing allotment, it's a split estate property right, I own the forage, I own the value of the land for grazing, I own all the improvements, I own the water rights, that would have made out an entirely different argument. But because they went in front of a judge and he wasn't able to articulate that, the judge had to assume that it was what the government was claiming, public land. It would be the same as if I owned 100 acres of land and you had a right of way across my land. And I didn't like you. And so one day I take you to court and I say, Your Honor, he's trespassing. He's crossing my land and he's not, he's destroying it. He's making dust. He's potentially harming endangered species, so on and so, ruining the view shed and so on and so forth. And you go in front of the judge and all you can say is, well, I don't think I'm hurting anything. And I even hired an expert and they did some studies and they say I'm not hurting anything. It doesn't matter. As long as I'm claiming I own the land and you're trespassing, then you're guilty. Now, on the other hand, if you say, whoa, wait a minute, Your Honor, I have a right of way. Now that makes out an entirely different issue now. It's two different property owners. And see, that is the problem with the ranchers in the West. They don't realize what they aren't able to articulate. Even if they believe that they own something, they're not able to point to a specific law and say, right here, Congress granted me this right. And that is what's killing us in the West. These laws already exist. There's no need for any new laws. In my opinion, every law that we need to take control of lands in the West already exists. It's just that we've been programmed into calling them public lands for so long, people forget that in reality, they're split estate lands.
Thank you, Doctor. I want to bring something up you didn't bring up, but really surprised me. You didn't bring up. Under the Prudent Man Act of 1872 through the Department of Interior, I have found that it is one of the things that does work. That it is, they say that it was the laws that changed to change the Homestead Act. However, I'm going to give you personal experience on it, and then you can give your opinion on it. But we have training areas where we train the Patriots, and one of them is deep in the mountains up in Colorado. Well, my wife just happened to find some gold, and I was already very well aware of the Prudent Man Act because I'd used it before. And on the Prudent Man Act, you're allowed to build a small cabin for security reasons as well as others. You have to post in a jar on your find under the Prudent Man Act. And we did all of this. Well, the Forest Service come up while we were camped up there, and we were right in the middle of building our cabin. And he come up, ordered us to tear the cabin down, gave us a bunch of orders, said they was going to write me tickets because we had put temporary floating bridges across a couple of creeks. And he informed me that we were in violation of the law. And I said, well, I said, sir, you hold up for a minute. This is the Forest Service law enforcement, the head honcho. I went in the tent that we had beside the cabin we were building, came back out with a little jar with about 3 ounces of gold in it. And I said, this is what we found. It's filed right there on the tree, which I'm supposed to do until we decide if we want to buy this land, because it was placer gold, which is $2.50 an acre. You can have you can claim a 20-acre grid per person, up to 8 grids. Well, he took pictures of what we had in the jar, put it back on the tree, and he told me, he said, well, I don't want you building any more on that cabin or anything until I check this out. I hadn't heard about it, all this, and he went in the rigmarole. But actually, all of a sudden, he just turned really nice. And he says, well, what brought me up here, he says, we had a report that between 40 to 400 men were up here shooting large weapons, which they were up there with 50 cals doing target practice and stuff. And I told him, I said, yes. And if you'll notice, right there is the flag that's flying. It's our Patriot flag. And he said, well, I'm not trying to walk on your constitutional rights in any way. We don't want another Bundy situation. And I informed him. I said, sir, I said, you are perfectly safe to come up here as long as you're coming up here as a friend. I said, my men won't do anything unless I give them an order. And he looked at me and he stood and he talked to me for a few more minutes. And he said, well, I'll be back up tomorrow. Well, next day he didn't show up. A couple of days later, he didn't show up. And we were getting ready to leave. So we packed up. We left because it was fall. We'd been there all summer. And when we got back home, I got a phone call from the forest ranger. And the forest ranger told me that he'd been up where we were at and everything was legal and everything, but he had to, but I had to file certain papers for a gold mine. And I said, no, sir. I said, this is the Prudent Man Act of 1872, backed by the Department of Interior. I said, look it up. That was the last time I heard from him. We still have that. We still go up there, and they've never bothered us since. However, we also found another gold mine that is pretty rich, and right now we're not able to work it because it is not placer gold, it's hard rock, but the inside of the cave, the roof is really dangerous. So we had one of the mine inspectors come in, and they said, we've got to secure that roof before we can go back in, which is fine because it's a safety hazard. And when we found it, another Forest Service officer, he happened to come by. We showed him what we found. His exact words was, you're a very lucky man. Well, right about 2 days later, here comes 2 women from the Forest Service. And they said, all we want to do, because what the second one we found was an old test mine where they got in about 30 feet back in 1924. It was abandoned. Just a little hole in the ground. We dug it out. Well, when they were digging, they were digging on the wrong side. Well, over the years, the dirt fell off of the side of the gold vein, exposing the gold vein. Forest Service went in and cleaned up all the clutter that they had left in there in the 20s. And they told me, they says, you're welcome to put a permanent place here 24/7. Under the Prudent Man Act, you're legal, which we had done the same thing there. And I've never had another problem with them. Have you heard of the Prudent Man Act of 1872? This act, like I said, is supposedly what replaced the Homestead Act. But you have to do $100 worth of work before you can file all the paperwork, get a geological survey to prove you got there, then you file papers in the court. Once you file the papers in the court and jump through all their hoops that they want you to do, which is a lot, then they give you a free title government fee to that land, and you can do as you want with it. Are you familiar with that?
Can you hear me?
Yeah.
Okay, well, I lost connection there for a second, so I didn't hear your whole question. The last part of it, I didn't get. But yes, I'm familiar with what's called the Prudent Man Test as part of the 1872 mining law. And in 1919, right after passage of the Stock Raising Homestead Act in this same time period, the Supreme Court said that between 1909 and 1916, Congress fully adopted this split estate policy where they would grant these surface rights to ranchers and where they would retain the mineral for separate disposal. And I know when Bruce Babbitt came in, he tried very hard to get rid of as many mining claims as he could. But the Prudent Man Test simply is that the amount of gold or of mineral that you discover would have to be sufficient to justify a prudent man in pursuing and getting a patent for that mineral. The only problem is with mining claims that were established beginning after 1919, it's been the policy of the Interior Department when they do grant patents that the surface use is only good until the mineral is expended. And that's what's in their regulations because of this grant of the service right, otherwise to ranchers, otherwise it would be a conflict. And I think the bigger mining companies, I think they're well aware of this, and that is why they favor land exchanges nowadays rather than trying to pursue a mining claim to patent. What they would rather do is do a land exchange. That way they get a free and clear service title without this limitation.
Right, but up in Colorado where we found this, you have a choice, and it doesn't say how long. As long as you do $100 worth of work of a year and prove what you have found, and you file all the right paperwork in the federal court. What they do, because I've already done this on two different pieces of property that we have out west. This had nothing to do with the cattle. This had to do strictly not mining laws, but the Prudent Man Act of 1872. That any precious metal that you find, you verify it's there, you can file under the Prudent Man Act to own that land. Once you have proven that you have to do $100 worth of work a year on it, and you have to be able to show what you have obtained out of the mine, and be able to have it with a geological survey. Now, you can get on hard rock mining, it's $5 an acre is how they do it. On your placer gold, it's $2.50 an acre. And we have all of our paperwork filed, everything, and it is ours. But I didn't know if you were familiar with the way that worked, because they have never come back, never bothered us, and we've been able to proceed with what we were doing. Like I said, one of the first words out of the Forest Service law enforcement's mouth was, "We don't want another Bundy situation." And I said, "There's not going to be." I said, "We are legal here. I have done what the law says. Here's the updated paperwork. I have the total files on the Prudent Man Act." And he wasn't familiar with any of it. But it's, on the Prudent Man Act is almost my Bible when I'm up there, because I can almost cite it to you word for word. And you get it through Department of Interior. But if you find the gold and it's supposedly on federal land, they cannot take it away from you. They cannot run you off of it. Actually, the other law enforcement agent that was there got very upset and walked off. She even tried to kick our dogs, but she walked off away. She didn't even want to even she didn't even want to hear the conversation. But it all turned out really good for all of us, because we still have it. And that placer gold, when we're able to go up there again and do mining, that is what's actually part of what's going to finance United Constitutional Patriot Group.
Yes, I am familiar with the mining laws, and the actual title to the 1872 Act is, I could look it up, but they don't call it the Prudent Man Act, but what developed out of that through the courts is what they called the Prudent Man Test. And it's, like I was saying, it has to be an amount of mineral that would justify a prudent man pursuing the mining of it. And so, yes, under the 1872 mining law, it is still valid, 100% valid. It's just, since after 1919, there's just a different type of patent that they issue if you do carry it to patent. But the thing is, you don't even have to carry it to patent. You can go forever and never even apply for a patent on it if you want. But if you do ever decide you want to pursue the patent, then after 1919, they give you what's called a limited patent. And the title is then only good until all of the mineral is expended, and then the surface estate would revert back to whoever the allotment owner. But I've been working on these kind of issues for a long time, and I think that all you'd have to do is go to that allotment owner and have him sign over under Section 9 of the Act of 1916, have him just sign over whatever surface, 20 acres, whatever surface right that he has to you. And I think that there's a lot of these issues, property issues, that have yet to been addressed, mainly because most people don't even realize that these are split estate lands out there. The government keeps people, in the dark. They keep people confused.
Right. Well, this paperwork I have sitting here in front of me on my desk from the Department of Interior, it says Prudent Man Act. And this is not private owned. This is Forest Service land. And it's the Prudent Man Act's only supposed to be good, supposedly, under the Prudent Man Act, on the Forest Service. But regardless, it's right in it, and we've already done it in the state of Oregon 15, 20 years ago, up by Babyfoot Lake. We found a mine up there, and we filed on it, and we ended up going into court. You have to run it in the paper for 30 days that you're filing to own that at $2.50 an acre. And the federal courts granted us a title free, which means you own that land. You have to pay taxes on it. It's the same thing as when you buy any other land, but it is your land to do as long as you want, but you cannot do it for timber rights, etc. You can only do it if you find a precious metal, and there's all you got to do is prove the quantity. Like that's all we had to do up here. It's already been in court, we just haven't finished filing everything on it because I've been too busy. But we have been accepted, and when we do get it, we've got 8 different partners that have worked the grid with us. That's 20 acres apiece. They all have to run together, and we've already got title fees on two different pieces of property doing this. And it is the same thing as a title to land, like when you buy a house or something.
Right. It is a patent. They issue a patent.
No,
but if you
no.
read
This is not a patent. It says title on it. It's not a patent. It's title.
Okay, well, that's a temporary, I guess, until the final patent is issued. But yeah, the Act of May 10, 1872, that can be found at 17 Statutes at Large, page 91. So anybody that wants to go look that up can look it up. You can go on to the Library of Congress. All these statutes and that I've mentioned tonight, you can go to the Library of Congress. It's a free website. And if you have the citation or the date, you can look up all these laws.
Yeah, one of the last time it was challenged in federal court was 1993 or 1994, and the only thing that they took off of the Prudent Man Act was building rock. Everything else remained the same.
Okay, can you still hear me?
Yes.
Okay, what essentially ended homesteading in the West was this act of Congress in 1923 when they confirmed all of these surface rights to these grazing allotments. That essentially put an end to homesteading because they couldn't issue a title to anybody else that on land that somebody else already had a claim to. So that's what essentially ended homesteading in the West. So even though the homestead laws, most of them continued and weren't repealed until 1976, that basically tied up all the land that was in grazing districts or in national forest districts. So that's what basically ended homesteading. So when people go into the BLM and they say, well, how come I can't put cows out there? How come I can't take up a homestead? Well, mainly the people at the local BLM or Forest Service office, mainly they don't know what the law is. And so they can't give you a real answer other than, well, if you want to put cows out there, go talk to the rancher that already has that allotment, because they don't know the difference between an allotment and public land.
I think pretty much covered what I had my question on you. I just didn't know if you had heard of it. But I appreciate you tonight, and I'm going to let Patriot Earl go ahead. This is your show, like I said, but I brought that up on the Prudent Man Act because a lot of people don't know what they can do. Oh, by the way, Dr. Angus, for some reason, it does not, the Prudent Man Act does not include BLM land. I don't know why.
Yeah, I don't know either. I'd have to look at some of the references to see why it doesn't. But
we lost you, sir.
I was just saying, you know, I don't know why it wouldn't apply to the BLM as well, because the Mining Act 1872, as far as I know, is still applicable to grazing districts. But you know, I could look into that a little farther and try to figure out why exactly. I do know that you do get when you get finally get a final patent for a mining claim, you also own the timber that's on the mining claim as well. So maybe that's why there's a difference between a grazing district and national forest, is because that component typically doesn't exist in a grazing district.
Very good possibility on that, because that's why one of the things that it says right in the Prudent Man Act is that you cannot file for the purpose of owning the timber. However, you have to write down literally every type of vegetation, species, everything in the area that you're filing on. So, like I said, I don't know. Maybe that's the reason why. But I'm going to turn this back over to Patriot Girl. And by the way, Dr. Angus, I'd love for you to come back on, because you've got still a wealth of information. We know that. And I personally want to thank you for being on the show. It was great having you on here. Patriot Cowgirl, you got anything you want to say to Dr. Angus before we move on to Gregory?
No, I just want to say thank you for being on our show. You're a wealth of information, and I know a lot of people out here in the West are very interested in what you have to say. So thank you for being a guest.
Thank you for having me.
I hope you'll stick around, sir. Okay, Greg, you want to introduce your next guest?
Oh, sorry about that. Yeah, sure would. In fact, we're on to more good news tonight. Boy, this is all good news. This is good news for the land, the people fighting BLM. But also tonight we have something really exciting. We've got a guest named Tom, and he's got like the coolest new technology I've ever seen. It's these are covers that go over curb. You know, these parking blocks. You know, the ones that always dent up my BMW because it rides too low. But, you know, I'm a marketing guy. I've been marketing all my life. I'm an advertising guy. And this really just blew my mind, because these things are beautiful covers that go over those parking blocks that we all hit in the grocery store. And they have advertising on them. And he's a big Trumper. So when he brought it to me, and he's been working on this patent for some time, he's really designed these things. That advertising's on the inside, so they're sort of like bulletproof. I'm not going to steal his whole thunder here, but I'm going to put some pictures up on them in the radio room so you can see some pictures of these things. But being a big Trumper, and these things are such talk pieces. I mean, people see them and they just scream at you. And so they can be Coca-Cola. He's got the local, Dairy Queen, and some of these other places that are using them. But it's brand new, and he wants to use this for Trump endorsed candidates. And they're talk pieces. You know, he's got some that are designed, say Trump train on them with cool trains on them, but they're really big. They're like 6 feet long. And I've never seen a piece of advertising that just screams at you, and they become conversation pieces. People come out. I don't want to tell his whole story, but I'll turn this over to Tom, but I'm going to put some pictures of these things. And what we'd like to do is just use them. He wants to do an exclusive with the RNC and Trump candidates, Trump supporters. We don't want the Democrats having something this cool. So I put something really cool together for Pete, and hopefully he can send that on to the president for us. And really, we would like to see this be a big part of the red wave and get the excitement going. You know, we're all about love and happiness on the Republican side, on the Trump side. You know, we're all about the love on the Trump side, but the other side's all anger and hate and obstruction and evil things like, you know, opening our borders and increasing crime and letting gangs in and letting rapists out and all the kind of stuff that the Democrats do. But this is something really happy and cool. that people just, I mean, they see these things and their mind just gets blown. So go ahead, Tom, you out there? He's been listening. Are you out there, Tom? Go ahead, take over.
I'm here. Thanks, Greg. Thanks for having me on the show. And thank you, Dr. Angus, for all of that information and sharing your knowledge with us. Greg's been a friend for quite a few years, and I've been in the media business for quite a few years. There's a difference between the media business and owning a outdoor medium. I'll give you an example. You know, we have TV, television, radio, we have talk shows, you've got the newspaper, you've got taxi cab advertising. What I've created is classified as a out-of-home advertising medium, otherwise known as OOH. So what that is basically saying that I own my own radio station, or I own my own newspaper. Because if I want to carry a message to a certain market or a certain city, what I would do is deploy, if you will, trying to create a picture here for everyone, the curb covers. My company is called Curbed Media. And what we have developed is a cover that fits over the wheel stop that all of the Americans pull up to and park on. Has two pieces of rebar that hold it in place. There are about 6 billion, that's with a B, of these across the nation. And about 2 years ago, I started working on this, and I'll give you a little background. I own a patent for a non-rotating wheel cover, which allows the tire to spin. But if you can envision a disc, a faceplate that covers your entire rim that has graphics on it, it allows the image to stay upright and readable as the car is moving, thus creating an anomaly that questions the senses of your mind. So that was my first product. It went on taxi cabs in the country, and we described it as sending soldiers into a city, whether it be McDonald's that was on the wheel. So the same thing came into play about 2 years ago when I started working on another project and investigating the parking lot curbs, wheel stops as they are known in the United States. And what would the feasibility be to cover these with a patented cover? You're basically talking about a form-fit cover that hugs the cement stone. There are about 3 models in the country that we've developed. So a little bit about the product. It's made out of a polycarbon, a plexiglass. You could call it a hockey rink glass or bulletproof glass. It's formed and fitted over the wheel stop. It attaches in about 5 minutes. Each one of these is approximately 6 feet by 14 inches to 16 inches wide once they're formed. That constitutes 90 of these to make up a 15 by 35 inch or foot billboard. So, and those billboards can run anywhere from $10,000 to $25,000 along the country's highways, and you would call it an A market in a city, depending on the amount of traffic flow. So once we finished this, just a few months ago in the intellectual property, I went locally here where I live and approached the Dairy Queen, which is in the heart of my city, and the Dunkin' Donuts. And these owners welcomed the product to brighten up their parking lots because, as everyone knows, the wheel stops, curbs, are dull and gringy, and they've become a part of the landscape in our country, just as billboards have. Billboards have become a part of the landscape in our country. So my thinking is that in the out-of-home advertising industry, the big box people and products like Coca-Cola and Pepsi and the rock stars and the Red Bulls of the world are always competing for the next great thing to come out for advertising. because things get mundane. The billboards of the country, I don't even look at anymore. They blend in. They've been here so long. So every time something new comes out, these people are fighting for that space. So now I've come out with a cover that allows the country, whether it's privately owned or a big box store or the patriots of the country, and that's what I thought of first was Donald Trump, and how can I help aid him in being reelected in 2020? And then I thought, how can we get this to all of the Trumpers across the country? Women for Trump, the guys, all of these people own businesses. They own commercial parking lots. They own a parking spot at their business. So to have somebody pull up at your business, let's take that one wheel stop that you pull up to every morning, and you're going to pull up and you're going to see, get on the Trump train with a big train across the front of that 6-foot parking stop that says reelect 2020. And on the back of it, depending on the parking lot, I came up with the image of America, a runner, and Trump. So similar to the Dunkin' Donuts, America runs on Dunkin', only on the back it's in red, white, and blue and says America runs on Trump. It's a powerful message, and I would like to get it out to the patriots in America, the true patriots, the people who follow Trump no matter what, which that's me. Those non-rotating wheel covers that I run on a pretty constant basis with Magna, with the Eagles, with Keep America Great. And again, it's about impressions. How many people per day will see that curb cover when you pull in to any parking lot across the nation? Listening the other night to Mr. Bundy share, my partner and I are considering going into Nevada and helping him win his campaign. That simply would be done by bringing as many of these curb covers that we can in populating Nevada. Again, this is not a radio station. You can have so many listeners, but it gets turned off. It's not a television show. You don't want to watch it anymore. You shut the station off. The out-of-home media and medium that I've created cannot be shut off. It can't be stopped. It is on 24 hours a day, 7 days a week, nights and weekends, holidays included. It is a nonstop broadcast. If you will, as the verbiage we used with the wheels, we'd be deploying soldiers, patriots across the nation to carry the message and to get it into everyone's hands. The impressions of who will see it that day across the nation. That's pretty much covers a lot of what I wanted to share with everybody tonight. Let me just think here for a minute if there's any other notes that I want to share. If Greg, if you want to jump in and maybe shoot a few questions, or anybody that's on with us tonight here, that'd be great.
Yeah, I just wanted to say real quick, not of course what we want, we're going to reelect Trump 2020, but over the next month, we'd like to see some of the Trump endorsed candidates, possibly the RNC, jump on this thing with both feet, because this is something positive. This is something that has huge bling. It's a conversation starter. People just migrate to things like, look at that, instead of that dungy old dirty, like the one I posted, nasty looking thing that always messes up my bumper. Those things are ugly and dangerous. This thing has like a Lexan cover so the advertising can't get hurt, but it protects the vehicles. And you just feel so much better knowing that you're pulling up to one of these things as opposed to something that's going to eat my bumper, some ugly, sorry about that. But, something very unattractive and dangerous, all of a sudden it becomes something that comes to life and people just migrate to these things. So we would like to
get the RNC involved immediately, and we'd like to.
We lost you, Greg. Okay, somehow we lost Greg, folks. Can you hear me?
Yes.
Yes.
Greg was having trouble with his phone jack earlier, so perhaps his phone got disconnected.
Okay, sorry, I'm back. Yeah, it's this stupid phone. But anyway, yeah, this is something really positive, really fun that we can put fun things on for the RNC Trump endorsed candidates, that we can get some real buzz going across the country, get more people on the Trump train. But also, like here in Florida, we have, governor candidate DeSantis, who I absolutely love. He's just a great man. He's looking out for our Everglades. He's looking out for our red tide problem, and we had a show on that. And he's a great man that will help our business in Florida. He'll create jobs. So we'd like to see over the next month. I'm sending sending some things to President Trump through Pete on this, and we really want his business, his great business mind and his connections and all those things to help us really this last month to really take these the red wave home. And I'm even thinking about putting the red wave on the back, the red tsunami that's going to be coming. And so this is just something that I really thought was a great timing. We had a month left till the election. And I'm really hoping that that the candidates are excited about it, and hopefully President Trump will be excited about it, and he will give us some ideas on how to take this home. So this was just a quick one tonight, but I tell you, this is something that's just a mind blower when you see these things.
Greg, is it possible to put a phone number out to everybody if they wanted to reach me, and any investment questions for raising capital to help get these out to the country?
Absolutely.
Our number here is a toll-free 833-200-0730, and you can reach either my partner, John, or myself, Tom. I'm at extension 801. John is at extension 802. So that number again is 833-200-0730, extension 801 or 802.
Great. One thing I wanted to say is really how impressive, we did some practice mocks on Trump train, beautiful Trump trains across these things. We did one with DeSantis, and man, I'm telling you, these things scream, and we want people to know those names. Name recognition is very, very big. A lot of people really are uneducated voters. They go in there and they don't even know what they're doing half the time, but they see a name that's like, oh yeah, I remember now, so you put DeSantis and you put some something environmental on there, that he's an environmental protector, or he's a good for business, or whatever the message is, and you put these things together, and it creates name branding, which is huge. Name branding is everything. I mean, some of these senators stay in office because they take their dad's name. People know the name. They get reelected. They don't even know who the new guy is. They just remember the old guy. So, this is huge to get name recognition, and to promote positive ideas, and to do it with a new product with such appeal. And everything that comes through my channel, which will be the political side, we will be giving some back to the United Constitutional Patriots, because everything that I do, I try to help the United Constitutional Patriots. So there's another reason I'm hoping that some of the patriotic candidates and people will get behind this idea, not only for the to win elections, but to help the Patriots. So that's all I wanted to say.
That's appreciated. I wasn't going to say much tonight, but Dr. Angus, I got a gentleman on the phone. His name is Ed Johnston, and he's got some news for you too that you might be able to touch on also, if you don't mind.
Okay, I didn't hear the whole question there.
Okay, I got a gentleman on the phone. He was one of our guests the other night. He's 100% constitutionalist, and he worked for the House of Senate for 15 years. He worked for, he's in Oregon. He also worked for a senator in Oregon for 5 years, and he's very active on filing a lot of legal stuff against the sheriffs and everybody else. But he has information on his property that he owns that you might be able to help him a little bit on, if you don't mind.
Well, I'll try. Go ahead.
Okay, Ed, go ahead, sir.
Oregon Trackers. And I've been involved, and I have never paid taxes in state or federal. And we're dealing with property taxes right now because I got associates of mine who never paid property taxes in over 25, 30 years because they filed their stuff out of the state situation. BLM can only register land deeds, allodial titles. The only one who does deeds is the city and county. And so there's a big difference of the city and county structure of the corporation compared to BLM is only supposed to register allodial titles. Allodial. And they're not really titles, they're just allodial certificate. And so when you get a certificate, that means you're a straight landowner. You don't pay property taxes whatsoever. And I know several people in several other states are in the same situation, and I've been fighting them personally myself because of the way I have done things and opened up even indictment investigations on some public employees that have gone away. And so this is the one thing that when you fight, they don't like you to fight and bring the truth out. So if you got something else that I might miss, I'm willing to get my number out. Johnny's got my number and pass information because I do have videos where Bureau of Land Management cannot have contact with the general public, and that was by their own attorneys in Congress. I have those video and audio tapes. They're not allowed to have contact with the general public, BLM employees. The only reason they got that was in 1996 by William Jefferson Clinton when he gave them the operation and authority to carry and pack guns, and to give them the authority of so-called authority, which they still don't even have today. They don't have authority to have contact with anybody. Are you familiar with that at all?
When I worked for the Forest Service, I went to the Forest Service law enforcement training, and the first thing that they told us is that we do not have general criminal jurisdiction in a national forest. So they're very well aware of that. But I think what they have done is adopted a strategy as well as a policy of trying to promote this idea that these are public lands, not split estate lands, and that they own everything and that nobody has any rights. And that's a policy that they're trying to promote and hoping that people are ignorant or that they don't find out differently.
Correct, and I'm on the same path because I have their flyers when they first started coming out with those, because I fought against them up at the Oregon State House and Senate with a lot of this stuff when they were bringing this stuff out, and people don't realize in the state of Oregon in 2000, Kate Brown and the governor, the Democratic Party, changed the Oregon State Constitution and put it so all the lawyers and the state attorney general owns all the land. And no living man or woman can own land. We already defeated that one, and we're fighting with them right now. That's why I still have the recall indictments on Kate Brown, because they don't have authority. See, these people, like you're saying, they get going off with some whim, and they think they have authority when they don't have any authority whatsoever, and you know that. And I was in that field. I know the structure before I even got involved in the other side. Because I had a dream going in law enforcement back in the 80s until I realized the real truth compared to what we think it is. Yeah, I think you're aware of that one, right?
Yeah, that's the thing. They try to put up this idea that these are public lands, there's no private rights of any kind attached, and using that, they try to assert this exclusive power, which the Supreme Court has already said they don't have. I think the whole problem is a lack of knowledge on the part of us, the general public. That is the problem. If we knew our rights, if the local sheriff and county
bloodline native structure, and that follows including under the 14th Amendment, because I don't have hunting and fishing license, never had them, won't have them. I've already got cleared because I'm a subsistence hunter and fisherman. But you have to be a lawful bloodline native. You cannot be a legal citizen to have rights. If you're a legal citizen, you have privileges 100%. And you know that one. Most people don't know the circumstances of lawful only works compared to what we've been indoctrinized to believe.
Hang on a minute, Dr. Angus, go ahead.
I was just going to say my area of expertise is on the federal law and the land disposal laws, and in jurisdiction, federal versus state. So when you get into issues, of a particular nature of between the state laws and the citizens, that's getting outside my area of expertise. So I don't know that I could venture any opinions on that, or the various state tax laws, because they vary from state to state.
Well, yeah, but I'm no citizen at all. Not at all. I'm no resident. Because if you're a resident or a citizen, you have no rights, period. End of story. And that's where the bloodline comes in. And I have all the laws, administrative records, the Supreme Court decisions behind closed doors and everything on my website on this that explains to people, if you're claiming to be a citizen or a resident, and I don't use zip codes because zip codes didn't come into effect until 1943. Prior to that, there was no such thing as zip code in this country because that comes under the domestic mail manual. And I think you're familiar with that, 602 of the domestic mail manual.
Like I said, my area of expertise is in the federal land disposal law and on jurisdiction between federal and state jurisdiction. When it comes to the post office or...
Wait a minute, you can't even...
In 2000, with no strings attached, and it was filed in the Secretary of State.
Okay, but that isn't the area that he's expertise in, Ed.
Right, no, I heard him. I'm just bringing up that point, but...
So, okay. And, okay,
thank you.
You're very welcome, my friend. Thanks for the call in. Ladies and gentlemen, I'm gonna turn this back over to Patriot Girl, or anybody has any comments, you're welcome to make them. I'd like to, just so everyone doesn't hit at one time. Chuck, you got any questions?
No, sir, I don't at this time. It's been an extremely interesting show. But actually, everything that was said was pretty well understandable, and no, sir, I don't have a question.
Okay. Tom, you got any questions? Okay. David, you got any questions? Okay. Pete, you got any more questions? Okay. Greg, you got anything else you want to add?
Well, I do, if just real quick, is I want to maybe have him back. But, in Michigan, they sold all of our mineral rights for the whole state to Canada and gave the resident, the people of the state absolutely nothing. So I would like to go back over some of this, and hopefully we can have him back on, because I don't understand how our mineral rights by the state can be sold to Canada and give the citizens of the state absolutely nothing. They claimed our benefit was it created 35 jobs. So yeah, I'd like to talk about this some more. Maybe not tonight, but I'm miffed at how all of our, the Upper Peninsula was always mineral heaven. That's where they shipped minerals, the ores, down to Chicago. The natives have been doing it for years and all that, all the way back. And we're a very mineral-rich state. And for Hillary Clinton and the crooked politicians just to sell all of our mineral rights to Canada, I'm trying to figure that one out.
Okay.
Can I answer that to him?
Do what?
I said, could I give him a partial answer to that one?
Yeah, go ahead.
The reason why why they're getting away with it. And this is the one thing what I have educated what we're doing to people is we're serving and suing the board members. We're putting them in prison. A corporation you technically cannot sue, but you sue a living man and woman who is designated and organized on that. And we're going to be getting part of that on my talk show tomorrow night, and then Sunday we're going over the Sixth Amendment. And we're dealing with tomorrow night, dealing with the Article 1 and the Article 3 courts. And this is the one thing that most people don't know how the courts work compared to what they think they are, because we have two real courts. One is an Article 1 court, legislative, and that's the court you always end up in. And unless you file for an Article 3 court, and you can't use capitals. When everybody writes capitals on their front page, you go to an Article 1 court, you have no rights. You give literally all your constitutional rights straight up right there gone. You have to do it on an Article 3 capital and small letters and know how to go file on a judge to get his oath and file in the courts. Most people don't know how to do that. And so to do that, and that's what I've been trying to get through the natives with the oil lines, is you got to sue the oil families, them personally, their own assets. And everybody keeps going, we don't want to do that. We don't want to do that. And it's like, then what are you bitching about then? You have no bitch, because if you don't go after the source, you know, you can't go after the dream of the myth of the dream, if that makes sense.
Okay. Well, thank you. Okay.
Thank you.
We're going to go on to Patriot Cowgirl. You got any questions?
No.
Okay. Now I'm afraid to ask this. How about you, War Dog? You got any questions?
I just like to thank the doctor for coming on the show and educating everybody, because he just like turned the light on a lot of things. And there is a situation going on in Nevada right now. I don't know if you know it.
No. Go ahead and fill us in quick, because we're running over time.
Well, you probably need to call Mr. Bundy.
Okay. I want to thank everybody for being here tonight. I was going to stay out of it, but I had to get involved in it because of what's going on. I definitely want to thank our special guests and thank you, Ed. I got an education tonight myself on a lot of things that I've heard about, but never heard any facts on it. We did get tonight. But with that in mind, I'm going to have Chuck close with the closing prayer, and then before anybody says anything, wait until we get all clear when we know we're off the air. So, Chuck, go ahead and close the show with our closing prayer, would you?
All right, sir, will do. Now, folks, before we say that closing prayer, I want to say one thing. I want to ask everybody listening to this show, to keep Judge Matt Kavanaugh and his family in your prayers. They have spent many days now trying to deliberately to destroy a good and decent man. And this man should be on the Supreme Court, and before it's over with, he will be. I'm asking everybody to keep him in your prayers. I've personally watched the hearings yesterday. I saw it with my own eyes. With my own eyes. A woman by the name of Sheila Jackson Lee, everybody knows who she is, walk up to one of her attorneys, the man, shake hands with him, and hand him a rather fat white envelope, which he stuck in his coat pocket. This woman absolutely sat there and lied straight through her teeth, and she was paid very well for it. So I'm asking you to remember Matt Kavanaugh, keep him in your prayers, that God will work through this evil and put this man on the court. Lord Jesus, we come before you right now, thanking you, Lord, for this opportunity that we've had to be here together to do this show, to put out this great information that we put out each and every week on this show, and to do this work on behalf of the American people and in service to you. We ask you, Lord, for your blessing upon this show and each and every show that we do in all of our efforts. We thank you for this team here that's been put together, that you brought together to do this work. We thank you for all of our listeners. We ask a special prayer tonight on behalf of Judge Matt Kavanaugh, soon to be Justice Matt Kavanaugh, and his family. We ask you, Lord, to place your hands upon them, to strengthen them, to encourage them, to be their strength and stay. We ask you, Lord, to continue now with each and every one of us. Continue to guide us, guard us, and direct us. To draw us ever closer to one another and ever closer to thee. For we do ask it all in the name of Jesus Christ. Amen and amen.
Thank you, Chuck. Ladies and gentlemen, I want to thank you for all the listeners. We're here every Monday, Wednesday, and Friday at 6 o'clock Mountain Time. Remember, voting's coming up. Folks, get out there, vote red. For every vote that the Republican doesn't do, they're voting for a Democrat. We need your help to keep Trump up there. We need help to keep the Republicans ahead of the Democrats in the Senate and Congress. And we need your help as Americans. You know, and one thing that I should have done, but it slipped my mind, I want to thank every veteran, every person out there in uniform that has been fighting for our country. And I want to thank the families of the gentlemen, the ladies and the men, the soldiers that have lost their lives protecting our country and our flag. More than anything, I want to thank America for listening. God bless you. Hope you're tuning in on our next show. And I hope you all have a great evening. And I want to thank all of our guests, especially David from South Africa. And I would like to welcome our guests back that were here tonight because they're good people. We've got Tom. He's a true patriot. He's got a product that I believe is awesome. And for you, Dr. Angus, I appreciate you being here, and I'd love to have you back if you would come. God bless you. God bless America. And good night, folks.
Thank you for joining the United Constitutional Patriots Radio tonight. We will be back on the air on Monday at 6 p.m. Mountain and 5 p.m. Pacific. So catch our next show, and God bless all you Patriots, and have a great night.